Hello, everyone, and thank you for joining us today. Our Secure 2.0 Deep Dive webinar today will focus on auto portability. Will it become the new normal or the new default? We'll talk a little bit about the legal parameters that apply to this relatively new feature. Auto portability, as well as the nuts and bolts of how it might work in your 401k or 403b plan. My name is Laura Ryan. I'm a partner in the Employee Benefits and Executive Compensation practice at Thompson Hine, and I'm joined today by my colleague Dominic DeMattis, also in our Employee Benefits and Exec Comp practice group here at Thompson Hine. In addition, we're joined by our special guests, Neil Ringquist and Renee Wilder-Guerin. I want to do a brief introduction of these two, and we're very thankful to have them participating on today's panel. Neil is the Executive Vice President and Chief Revenue Officer of Retirement Clearinghouse. He's been at the forefront of developing and delivering innovative wealth management solutions to the retirement and investment advisory market for more than 25 years. Prior to joining RCH, he was with Advisor Software, where he served as president and COO, and prior to that was vice president sales and marketing for Morningstar Associates, a registered investment advisor. Neil holds a bachelor's degree in economics from Middlebury College and a MBA from University of Chicago. Renee is also joining us from Retirement Clearinghouse. She's the Executive Vice President of Public Policy, focused on advancing retirement savings, public policy matters that preserve retirement savings and increase retirement security for all Americans. Prior to joining RCH, Renee was Director, Office of Enterprise Planning for the Federal Retirement Thrift Investment Board, responsible for driving the vision, strategy, and execution of the Thrift Savings Plan, the nation's largest defined contribution plan. Renee has both a BA and an MBA from Duke. We're very thankful to have them with us here today to talk about this topic. A couple of quick reminders before we dive in. Today's webinar is being recorded, and the recording will be sent within 2 business days of the program to anyone who registered for the program, along with a copy of the slide deck that we'll be using for today's program. Also, if you have not already signed up, please remember that our final webinar in this Secure 2.0 Deep Dive series will be held next month on November 29th. We will be looking back and re-reviewing some topics that we covered earlier in the year. We'll be looking forward as to what's coming in 2024 and 2025 under Secure 2.0, and hopefully by the time of that webinar, we will even have some new guidance on some of the Secure 2.0 provisions that we can review and discuss during that program. For today's program, please feel free to use the question panel in the upper right-hand corner of your screen to ask questions. We will try to address questions asked kind of as we go along and are covering the material, or at the end, time permitting. And if we don't get to all of your questions, we will follow up after the program. So with that, and without further ado, I'm going to turn it over to my colleague, Dominic, who is going to begin by sharing a little bit of the sort of background in legal landscape that is important to understand before we really get to the heart of the topic of today's topic, auto portability. Dominic?
Thanks, Laura. We're here today kind of to, in addition to, talk about the provision, also to hopefully help to demystify it a little bit, this new auto portability provision. My view is that this hasn't received quite as much attention as it deserves. And, I guess the fact that most people spent much of the year focused on required provisions, such as the now delayed, Roth catch-up provision, likely has a lot to do with that. But before we get into exactly what auto portability is and exactly how it works, we, as Laura indicated, thought it would make some sense to spend a few minutes discussing relevant pre-secure 2.0 law and how things have been working in practice under that current legal landscape or the pre-existing legal landscape in order to clarify how exactly we got here. How did we get to auto portability? So as described on the slide, you can see, the general rule that we know is that before normal retirement age, amounts generally cannot be distributed from a retirement plan without a participant's consent. At and after normal retirement age, benefits can be distributed, but without consent, at least from the perspective of the participant's consent. But that would need to be set forth in plan terms. Of course, benefits must be distributed or commenced under the required minimum distribution rules. In all these cases, spousal consent may still be required. In terms of participant consent, there's an exception that we know about for small account balances or small present values that are under $5,000, which will be increased to $7,000 effective January 1st, 2024. And by the way, that change from 5 to 7,000 is optional. So among the other things on your radar, you should be thinking about whether or not that's a design change you'll make to your plan. For these small cash outs, if the amount is $1,000 or above, they must be in the form of a direct rollover to a default IRA, unless the participant affirmatively elects to receive cash or directs the rollover to a different IRA or to an employer plan of their choice. It's a common plan design to pay auto outs, auto force outs or auto outs in the form of a lump sum if they're under $1,000. Now, that brings up, there's some pros and cons to these auto outs, if you will. Laura, I think you were gonna maybe take a minute or two to talk about some of the practical consequences we've seen resulting from the auto outs in our practice.
Yeah, and I think those include, what is often referred to as leakage. So it ends up resulting in, retirement savings, certainly of small balances less than 1,000, sort of exiting any type of retirement savings vehicle, and those that fall within the 1,000 to 5,000. Ending outside of a 401k plan, nonetheless still in an IRA, but does tend to result in this leakage concept. The next block really talking about resulting in a large number of very small balance IRAs, belonging to individuals who oftentimes are non-responsive or for which there is not good contact information, again, often referred to as missing participants. And can also result in uncashed checks. Does result in uncashed checks, and sometimes that list gets quite long, especially for those balances that are being paid in the form of cash that are less than 1,000. And these issues, these consequences have really come under scrutiny in the last several years by the Department of Labor as items that allegedly fiduciaries are not paying close enough attention to and should be doing more to avoid or mitigate.
Right. So along those lines, essentially the auto out regime, that we're just talking about, there's been this DOL enforcement that's kind of been alongside of it. So just to put a little pin on that, the terminated vested program, which we all know and love and call the missing participants program, actually started in the Department of Labor's Philadelphia regional office many years ago, almost 20 years ago, and it became a national enforcement priority. DOL's theory in a nutshell is that it's explicit in ERISA 404 that a plan fiduciary's obligation to act solely in the interest of participants and beneficiaries and for the exclusive purpose of providing benefits to participants and defraying reasonable expenses, that essentially, how could a fiduciary do that if they don't know where people are? You can't pay benefits if you don't know where people are. So, now we can debate about the method the Department of Labor chose in that case to get the word out, whether investigations that led to a trickle of news and then horror stories was the right way, or maybe if they could have published some type of brief guidance of general applicability, reminding fiduciaries of their duties. But you know, in my opinion, it's kind of hard to argue that fiduciaries don't have an obligation to keep track of their participants so that they can actually do what ERISA 404 says, which is pay benefits. So, you know, we raised that because that enforcement mechanism, or that enforcement means, you know, kind of had other consequences that, you know, led to maybe an increase of this issue or these problems that Laura was mentioning. So in addition to that increasing a focus on policies and procedures that are intended to better, you know, locate missing or non-responsive participants, it also led plan sponsors to make plan design changes, such as increased use of auto force out programs, resulting in even more leakage and missing participants, you know, putting assets outside of ERISA into an IRA, and uncashed checks for the under 1,000 folks that Laura mentioned. In what that did essentially was outsource the problem. And with the exception of uncashed checks, which are still a plan problem, the missing participants, you know, all that really did was it took those folks who were missing or non-responsive from an ERISA plan and put them into an IRA outside of the ERISA space. Note that to the extent an a deemed or default IRA, you know, is deemed dormant, so somebody's missing, and then they haven't done anything with that IRA over a period of time that would depend on state law, the IRA trustee actually would be required to escheat or otherwise turn over that amount to the state under its unclaimed property law. So it's against that backdrop that Retirement Clearinghouse really first started working on a potential solution to the problem that would retain the pros, if you will, the benefits of the auto out system, while substantively addressing the cons or the consequences of that system in a manner that was intended to help solve the problem rather than outsourcing it to a third party. So with that, we'll turn it over to the stars of the show, to Neil and Renee, to help us walk us through the steps that Retirement Clearinghouse has taken and the reason they took those steps before Secure 2.0.
Yeah, thanks, Dom. So, you know, with auto portability, think about what we're trying to create here, which is a default path for portability. And the reason being is the leakage problem that Dominic described. And so rather than require in a portability scenario an individual to opt in and do work to move the balance, specifically small balances, the thought was, well, you know, let's have it be an opt-out like other good working defaults that are improving plan design today. So that's sort of the motivation behind this, and the significant public policy benefits that go with plugging cash out leakage. Now, Dominic described the sort of the regulatory framework for the force out. So if you're doing a default to move a balance from plan A to plan B, you need to force out on a negative consent basis and then roll in on a negative consent basis. And Dominic described the force out provision. So in essence, what auto portability is doing is wrapping around the existing mandatory distribution regs. Now, the issue was there was nothing that spoke to the roll in part of this. And so we started down this path. You know, Retirement Clearinghouse is an automatic rollover provider, and we realized, you know, fairly early on, 10 years ago, that the Safe Harbor IRA was just simply not a good destination or produce good outcomes for retirement plan participants. That the best path was to actually retain these assets in the system because it substantially cut down on leakage, but it also kept these assets more appropriately invested. I'll quantify both of those in a minute. So that's 10 years ago we sought to move forward with this auto portability concept. Now, the first thing we did was obtain a legal opinion that indicated there were existing precedents of negative consent in the retirement plan market that would allow an automatic roll-in. But at the time, we had a working group of record keepers that were giving us guidance on this, and they said, well, we'd be more comfortable if you went to the Department of Labor and got specific guidance from the Department of Labor. So off we went and submitted our application, and after many long years of working with the DOL, we finally did get that guidance in the form of an advisory opinion in 2018 and a prohibited transaction exemption in 2019. Now, the advisory opinion spoke to who the fiduciary of a negative consent transaction was. And the advisory opinion basically stated that Retirement Clearinghouse is the fiduciary for all negative consent transactions in the Retirement Clearinghouse auto portability program, not the record keeper, not the plan sponsor. Because Retirement Clearinghouse was pulling a fee on a negative consent transaction, that is a prohibited transaction for which we need an exemption. So we went through the exemption process. We had, at the time the advisory opinion was issued, we got a proposed exemption. Took a little longer. This happened around the time of the previous government shutdown. But we ended up getting that prohibited transaction exemption in 2019. The importance of the prohibited transaction exemption is it provided the operational guardrails for how an auto portability program works. And many of the guidelines that are in the prohibited transaction exemption also appeared in the legislation, which we'll get to in a minute. So think of guardrails such as how often the locate queries to try to find somebody in an active participant plan. I'll describe this in a moment. Or the definition of an active participant account. Or how much time do you give somebody to opt out of the program? All those sorts of things are baked into the prohibited transaction exemption that was issued. Now, one of the drawbacks of the prohibited transaction exemption is it did have or require a 5-year renewal, had a 5-year renewal requirement, basically. And that was problematic in the sense that it created some hesitation with record keepers and plan sponsors around the permanence of auto portability. What would happen if we signed up and the Department of Labor decided to pull auto portability? So that was the big reason why we sought a statutory exemption through legislation, is to avoid having that 5-year renewal period. And we'll get into the legislation here in a moment. What I'd like to do, though, is define the sort of the public policy issue. And this is important because it's the reason why we've received bipartisan support in Congress for the 10 years we've been working on this. I mean, the support, we got started with a letter of support, a bicameral letter of support with representatives from both sides of the aisle supporting auto portability. The legislation had bipartisan support. And the big reason why is the overwhelming public policy benefit of auto portability. And it really goes to plugging cash out leakage. So if you look at the tiny colored chart on the very left, this speaks to leakage of all retirement plan balances. And roughly about, I mean, it depends on what study, but if you aggregate all these studies, roughly 1/3 of all retirement accounts cash out at some point in time. In this particular illustration, it's within 1 year after retirement. That problem is particularly egregious with the small plan, with the small balance accounts, that under 5,000, where 55% of these accounts are cashing out first year after job change. Now, what's a big driver of that number, obviously, are Dominic and Laura touched on this, the fact that many plans adopt the under 1,000 cash out provision and just send checks. That's part of that goes into these numbers. But just through, for example, the automatic rollover process, the easiest thing for these participants to do is simply take the cash and incur taxes and penalties. And that 55% is just first year after job change. You know, we looked at what cash out leakage, if this in these accounts after 1 year, for example, years 2 through 7, and another 20% of these accounts cash out. So upwards of 75% of these accounts are cashing out or feeing out after 7 years. So it's a particularly egregious problem. And not only that, it's who is cashing out. It's the undersaved and underserved. So this middle chart speaks to that. you look at, and this is overall cash out rates, that minority Americans are cashing out at much higher rates than your average DC participant on the left, as well as low income participants. So it's the undersaved and underserved that are cashing out. So if you want a quantifiable program that addresses the minority wealth gap, certainly auto portability is one potential program. And while the balances might be small in this segment, the aggregate of these balances is quite large. And this was the chart on the very right. A couple of years ago, eBree did an analysis of perfect portability in the market. And in the under 5,000 segment, if we plugged all cash out leakage, what would that mean over a generation, over a 40-year time horizon? And their number on a present value basis was 1.5 trillion. So that's a meaningful number. And below that, you can see the incremental savings accrued for those that are undersaved and underserved, those that would most benefit from a program of auto portability. The next slide speaks to the second public policy benefit. And when EGDRA was passed in 2001, the primary default for accounts in a 401 for participants that hadn't given an election, investment election, was a money market fund. Obviously, 2006 and the Pension Protection Act changed that quite a bit, but EGDRA was passed before then, and the requirement for investment in a default IRA is that it's principal protected, that it's a money market instrument. And so you have accounts languishing in these safe harbor IRAs that are underinvested, and they're in there for quite a long time. So what these charts show, these are eBree charts. On the left-hand side, eBree has an IRA database, and you can see the bubble of accounts they have in their database under 5,000. So it's a large bubble. Those are safe harbor IRAs. And then on the right-hand side, you look at the duration of time that those accounts are still invested in money assets. And you can see a very large percentage over long periods of time are still invested in money market investments. So that's the second primary public policy benefit, is the underinvestment of these balances. So naturally, in a program of auto portability where those balances are retained in the retirement system, and they're kept in plans where the majority of plans have a default that's a target date fund, a much more retirement appropriate investment than, say, the money market fund that's the required default in a safe harbor IRA. So those are the public policy benefits. I will turn it back over to you, Dominic, to talk about Secure 2.0, or Laura.
Actually, I think it's me, Neil.
Oh.
So as Neil had indicated, the Department of Labor gave Retirement Clearinghouse a PTE to enable auto portability in 2019. In 2022, Secure 2.0 codified the provisions of that PTE, and it extended those provisions not just to Retirement Clearinghouse, but to any potential auto portability providers. So it opened the market for auto portability. And as Neil mentioned, it gave permanence to the exemption. So we no longer had to go back to the department for a 5-year renewal cycle. The legislation becomes effective after the December 29th of this year, but it is pretty much the same thing as the PTE, and so we are in compliance not only with the PTE, but in compliance with the legislation in the running of auto portability. So we go to the next slide. So the provisions, as I had mentioned before, are pretty much a carryover from the PTE. I guess one of the most important issues is that the auto portability provider must acknowledge that in moving the participant balances, they're acting as a fiduciary. The legislation also requires that all plans be kind of on a level playing field. They operate under the same terms. And in fact, they sign the same contract. I think Neil mentioned already that searches have to be done on a periodic basis. I think it's 30 days or on a monthly basis, actually. So that's searches to locate active participant accounts. The fees are open, transparent. They must be included in our communications and notifications, and they must be reasonable. We had our first audit of 2022, so that covered all of the notices for auto portability from the very beginning, where the participant is notified that they are eligible for auto portability. It informs them of their ability to opt out and how they go about doing that. The notifications disclose the fees. And at the completion of the transaction, the participant receives a notification confirming that their previous account has been ported over to their new employer account. There are requirements that we retain the data for 6 years. It's kind of, I would say, in line with pretty much what the expectations are of record keepers in general. There's a specific requirement that the data not be used for marketing purposes or cross-selling. And again, I think I had mentioned we have an annual audit requirement for auto portability. So by and large, things are pretty much the same in the legislative language as it was in the PTE. I think I'm turning it over to Laura now, or is it Dominic?
I think it's back to Neil, Renee.
Oh, okay, sorry.
All right, so let me walk through the auto portability solution that's in the market today and how this works. And it's offered by Portability Services Network, and I'll introduce that in a moment. But auto portability as a solution, let me go back, a single plan adopted it on an affirmative consent basis, but all the same technology back in 2017. This was under a program called Retirement Clearinghouse Auto Portability. The first record keeper joined in light in 2020, again, under Retirement Clearinghouse Auto Portability. And then Portability Services Network was formed last fall, last October. And we're just going live with the Portability Services Network version of auto portability this month. But it's always worked the same way. And let me describe that before I get into the specifics of the Portability Services Network. Okay. So in essence, what we've created is a network. It's a clearinghouse. And we're piggybacking off the existing mandatory distribution regs. So if you look at this recycling chart, everything above the dotted line is existing today. That's the standard automatic rollover process. Okay. Now, when the Department of Labor issued their prohibited transaction exemption, they spoke to 3 configurations of auto portability and how it could work. Okay. And those configurations address where a balance is sitting, a terminated participant balance is sitting, while we're looking for the new account balance, a new employer account balance, or the active employer account balance of that individual. So basically, the Department of Labor anticipated three locations of where that balance could be sitting. One is in a retirement clearinghouse safe harbor IRA. So in other words, the mandatory distribution process occurred independent of auto portability, meaning the plan had established a force out provision. That force out provision said after so many days, 30, 60, 90 days, the individual that's terminated would be forced out of the plan and would go to a retirement clearinghouse safe harbor IRA. And the balance is sitting there while the network is looking for their new employer plan account. So that's location number one. Location number two is in the safe harbor IRA offered by a record keeper. So obviously a lot of the large record keepers have their own safe harbor IRA programs, Fidelity, Principal, and so forth. And similar to the retirement clearinghouse safe harbor IRA configuration, it's the same thing except where the automatic rollover process occurs independent of auto portability, and that balance ends up in a record keeper safe harbor IRA, and that's where it sits until they're located and matched and ultimately moved to the new employer plan. Okay. The third configuration, what the Department of Labor deemed a conduit configuration, the balance sits behind in the former employer plan. And it's only forced out after the individual has been located, matched, gone through the consent process, and then the money moves. So in other words, the automatic rollover process of the mandatory distribution process is tied directly to auto portability. It is driven by auto portability. However, you still have to meet the mandatory distribution regs. So it has to be forced out to a safe harbor IRA before it flows into the new employer plan. And where it gets forced out to is in a no-fee conduit IRA over a matter of 2 to 3 days. So that's the conduit configuration. All right, so keep that in mind. There's no configuration where there's any other sort of third-party IRA provider in the middle of this. So any other third-party IRA provider, for example, would have to be a subcontractor to a record keeper under the record keeper safe harbor IRA configuration. All right. So those are configurations. Now in this network, I'm sorry, Laura, I'm still going through this process here. Every record keeper in the network and every sponsor in the network is both a sending and receiving record keeper and sponsor. Okay. All this is done. This network is all connected via APIs. And what happens is, in the locate process, all the record keepers in their capacity as sending record keepers send data on accounts that are eligible for auto portability. So either they've been force out IRAs that came from plans that had signed up for auto portability, or they're terminated participants sitting in plans that had signed up for the conduit configuration. Those get sent to Portability Services Network. Portability Services Network aggregates that data, and that data consists of simply a social security number and account number. Portability Services Network randomly generates a number to map to that account number, drops the account number, and then sends the two pieces of data back out to all the record keepers in their capacity as receiving record keepers so they can query the active participant records. Okay. What we're in essence doing using Social Security is trying to locate an individual as an active participant. And those queries are only querying plans that have signed up for auto portability, the active participant records of those plans that have signed up for auto portability. When an individual is located by Social Security, the receiving record keeper sends a match file. They drop the Social Security number, they keep that randomly generated number, add a batch of demographic data, and send that to Portability Services Network. We look to the account number that randomly generated number was mapped to, ask the sending record keeper for the same data set, and run the two data sets through a match algorithm, determine whether the individual is one and the same. To the extent the match is confirmed, then that record goes through a consent process where the participant has the opportunity to opt out or consent. And they're given certain timeframes depending on configuration to either consent or opt out. Simply consenting expedites the process. If they're just non-responders, once the timer expires, then the automatic roll-in process kicks in, and the roll-in occurs. And then in the new employer plan, the balance is invested according to the standing investment instructions for that particular account in that plan. The Department of Labor dictated what an active participant account is for auto portability, and it's one that has either received a contribution or done an investment election within the prior 3 months. So that is how auto portability works. One other point before we move to introducing PSN is a notion of reciprocity. In a level playing field. Basically, every record keeper has signed the same operating agreement for auto portability. There's no most favored nations clauses. There's no benefit to any one single record keeper. And the sponsor agreement is similar. It's largely a template agreement, so no one sponsor or record keeper benefits over another. That's the nature of a level playing field in a clearinghouse. That requires rules of reciprocity. So let's say, for example, a plan is currently today is just cashing out balances under 1,000. They want to sign up for auto portability, but only for that population under 1,000. Keep balances over 1,000 in the plan. That's perfectly fine. It's just on an automatic roll-in basis, on a negative consent basis. That plan will only accept automatic roll-ins of balances below 1,000. So that's the reciprocity that's built into the rules in the system network-wide. So I'll stop there on the operational front and move to introduce the Portability Services Network. So this was last October where the new consortium was announced, and it received a lot of news. And the reason being, and it's not that auto portability was a new concept. As I mentioned, we had announced a couple of record keepers retirement clearinghouse had, in Alight and Vanguard, prior to the formation of the consortium. What was new was that record keepers came together to solve an industry problem in a coordinated way, to form a consortium to solve the problem of cash out leakage of these small balances. And so it's the first time the record keeping community cooperated to solve an industry problem and create that consortium. And that was what was newsworthy, both in the national press and in the trade press. So let me talk a little bit about how this consortium is put together. So today, the consortium is 51% owned by Retirement Clearinghouse and 49% owned in equal shares by 6 record keepers: Alight, Vanguard, Fidelity, Empower, TIA, and Principal Financial. Now, they're the member owners. The member owners are responsible for governance of the Portability Services Network entity. There is no revenue that is accruing to any record keeper that is either an owner or participates in the network. So while these are the member owners, all record keepers are encouraged and are joining the Portability Services Network, and all record keepers, including the member owners, are signing the same operating agreement. So these 6 have signed separate agreements that deal with the organizational structure, the intellectual property transfer, and the operations of Portability Services Network. But the operating agreement that they've signed for auto portability is the same one all other record keepers sign. So all the record keepers are signing the same operating agreement. The consortium will ultimately be 100% record keeper owned. So over a 10-year period, the intellectual property for auto portability will transfer to these record keepers, and they'll have full responsibility for owning and operating Portability Services Network. The goal of these record keepers is to operate it as a utility at the lowest possible cost to the participant. And that's how it's being run today, with the intent that that cost goes down as transactions scale up. So today there's a one-time fee of $30 for auto portability. Again, that's one time for all balances over $600. For balances between 50 and 600, the fee is 5% of the account balance. And then all balances less than $50 are processed through the network at no charge. So the intent of this is to literally clean up all the issues that we have with uncashed checks. You think of these residual dividend payments that oftentimes end up in very small account balances and so forth. All that would be cleaned up through auto portability. And that maximum one-time $30 charge will come down. You know, likely the first step down will be to $24 and then to $20. And that's when the network will be fully operational with the 6 record keepers. Today, the 2 record keepers have gone live this month. Next month, the 3rd record keeper will go live. The other 3 member owners will go live in 2024, as will other non-member owners. Currently, the 6 that have signed up represent about 63% of the market in terms of participant market share, just to give you a sense for the scale today of Portability Services Network. And we're in discussions with another dozen or so record keepers that would bring that up to about 80% of the market share. So I'll stop there. That is Portability Services Network and auto portability as a service today in the clearinghouse. In other words, the commercial solution that is available today to match that statutory exemption that is in the Secure 2.0 legislation.
Thanks, Neil. That, you know, Dominic said at the beginning, we wanted to reduce some of the mystery around what auto portability really is. And I think you did a great job, you know, of breaking this down and explaining exactly how it works, you know, what some of the terms and conditions are that apply, including the fees. So thank you for that. I think with that, we, you know, just wanted to reiterate, I think, a couple of observations as it relates to auto portability. We've already touched on many of these points, but from a participant perspective, you know, this feature, again, it's optional, but if you do, you know, choose to work with your record keeper to add it, no doubt will preserve, you know, help to preserve retirement savings and reduce that leakage issue. You know, will ultimately improve long-term return on investments. As Neil said, the concept here is to keep the assets in 401k plans and in the investment options that are available through 401k or 403b plans, and ultimately help to reduce fees, you know, especially for those accounts that would have languished, for example, in default IRAs without the auto portability feature. Dominic, from a plan perspective.
Yeah, from a plan perspective, you know, our observation is that, you know, this can significantly help with discharging fiduciary obligations with respect to missing non-responsive participants and help to minimize uncashed checks. You know, in other words, I guess the way I'd phrase it is, you know, this auto portability retains the benefits of the auto out from a fiduciary perspective, because of course there are things that help on that end. But with an inducement to also include those who are under $1,000 to a default IRA, which is a big deal from the leakage perspective and from the kind of the abandoned IRAs, the IRAs that just sit out there. So rather than just sending a check to somebody, I mean, by definition, often we're talking about people who are non-responsive, and sending a check often results in it not being cached. It does come with the requirement. There is monitoring and oversight. There's a new fiduciary out there, and there is a fiduciary safe harbor for the auto out, but there's no explicit, and we'll get into this in a little bit more detail in a minute. There's no explicit fiduciary safe harbor for the auto in. And again, then the new player would be the Portability Services Network, PSN, which there's some level of monitoring and oversight, of course, required. But I say the slide here says I say that there is no explicit fiduciary safe harbor for the auto in, but Renee walked us through the Secure 2.0 statutory language, which at least in my mind appears to effectively provide a fiduciary safe harbor, or at least arguably it does. So there may not be a need for an explicit fiduciary safe harbor, or there may not be a need for DOL to say certain things more, but again, we will talk about that a little bit more in a minute. And to that end, Neil, Renee, can you provide your observations regarding first what your research indicates are the benefits of auto portability, and then after that, any thoughts on additional guidance we may need or we may expect from the Department of Labor?
You bet. Renee, how about I take the research and you take the Department of Labor?
Okay, sounds good.
So we'll start with the research, and that's the charts that you have up here, Dominic. So if you think about what auto portability is doing, it's removing accounts from the system, but retaining the assets. And when you do that over a long period of time, the benefit to the plan is that it increases average account balance over time. Simply, you're consolidating accounts, so you're reducing number of accounts and keeping the assets that would otherwise cash out in the plan. So that's the primary plan benefit over time. The research shows is a fairly substantial increase in average account balance over time. And then the residual benefits that Dominic and Laura talked about were around the administrative responsibilities that plan sponsors have with uncashed checks and missing participants. Certainly on the uncashed check side, all these programs of cashing out balances under 1,000, those can be put through the auto portability side. Then that's a large source of potential uncashed checks right there. So it's those administrative issues that also get certainly mitigated to a great extent with a program of auto portability.
Okay, so the AP legislation basically directed the Department of Labor to issue guidance as may be necessary, and I've got my hands up in air quotes there. And it largely related to kind of some operational issues. We have met with DOL a couple of times this year, and DOL has indicated that they are supportive of auto portability and believe that it makes sense to allow the network to run and for us to gain experience, us collectively, that being DOL and PSN, experience with auto portability, and that this happened before they layer on potentially any other guidance. I think this is, and they also indicated that they didn't feel that they needed to issue operational guidance since there's only one auto portability service provider. So we don't anticipate, we don't know, of course, but we don't anticipate that there will be any type of operational guidance coming out of the department in the next several months. That said, the Department of Labor does have a requirement, a reporting requirement to Congress on a number of elements that are portability related. Things like the number of transactions, the number of accounts, the number of safe harbor IRAs that get feed down to zero, those types of things. And we are going to work actively, proactively, I should say, with the department to make sure that we provide them the data that they need to complete their report to Congress. It's to our benefit that they have accurate data. But I also think that PSN can aggregate data from industry, specifically our member record keepers, and hopefully make DOL's reporting requirement a little bit easier. And finally, I do hope that they don't promulgate regs to require the industry and PSN to provide this data. I think that we are trying to demonstrate to them absolute transparency and a willingness to assist them. So I don't believe that we will get regs in the next couple of months. I do believe that our conversations with them will continue, not just around the data requirements, but we are talking to them about auto portability, what we're doing, keeping them abreast of what's going on. And certainly as everything gets going now that PSN is operational, we will be proactively sharing data with them. So I think that's, yeah.
No, thank you. Thanks, Renee. We'll try to wrap it up here quickly. So you've heard it, you're interested in it, you want to think about it. I mean, what are your next steps? What should you be doing? Well, first, I mean, as we talked about earlier, look at your cash out limit. Are you going to increase it to $7,000? If the cash out limit is $1,000, and will it be, or excuse me, yeah, will you, if you one of those plan designs where you've limited your cash out limit to only $1,000, so you don't have a default rollover, then will you change that, number one? And number two, would you extend the automatic rollover provision to the folks under $1,000? And if your 401k plan record keeper is one of those participating in the PSN, well, you may want to start to collect the details now regarding the option and determine whether to adopt it. And in that case, I think we would, or at least I would, encourage that you look at including those under $1,000 balances into this. Laura, can you maybe put a bow on it and maybe recap the steps that are required to consider adopt auto portability on the next slide?
Yeah, definitely. And I think, certainly, inquire if your record keeper is one of the members of, PSN. What are they offering? When are they offering it? What are the terms and conditions? But we would, anticipate or we know that some of the steps that would be required in order to proceed with an adoption of auto portability, would clearly involve a review by the fiduciaries of, the implementation of this new feature, the fees, the agreements, provisions around cybersecurity, et cetera. All of the, confirming that the requirements, reflected in either the prohibited transaction exemption or the statutory provisions under Secure 2.0 are being followed. May require a plan amendment, depending on the current language in your plan regarding cash outs, and in particular how quickly an amount might be, quote, cashed out, given that it could take time to find a match for that individual. Service agreement amendments may be required with your existing record keeper. A new agreement with PSN would be required. There's going to be, participant communications that you're going to want to get copies of, review, regarding the auto portability feature. And beyond specific communications, if you're adopting this new feature for your plan, you would presumably, mention this as part of the summary plan description for your plan. And then ongoing monitoring, of the service, as was referred to. There are audit requirements, and you're gonna, as a fiduciary, want to be knowing that those audits are being performed, getting copies of the of the audit reports, to demonstrate satisfaction of your fiduciary obligation here. We did have one question come in that maybe I would throw out at this point. It's kind of a observation. Trying to understand the interaction between auto portability and cash out. Is there increased risk to the plan from a lost participant perspective? If we're keeping these small balances in the plan longer while we look to see if there are matches in the network, it seems there is a risk these participants move, i.e. get lost before any action is taken on their accounts. I think, there's certainly, that could happen, but Neil or Renee, do you have any projections around how often you would expect matches to be made, and or how quickly you might expect those matches to be made? Because I think, if we expect those numbers to be, relatively high, then I think that, counterbalances the risk, to plans that retain these balances in their plan longer and never find a match and, end up with a missing participant.
Yeah, Laura, this is Neil. So it depends on what configuration the record keeper is supporting. So for example, there'd be no difference if the plan continues with its normal automatic rollover process, right? Mm-hmm. It's only if they move from an arrangement where they were forcing out an individual when they were eligible to, I'll call it the conduit configuration, where those balances stay in the plan and are only forced out when a match occurs. It's only then could they experience issues with missing participants because those balances are staying in the plan longer. So it's only in that scenario would there be, I'd say, an increase in potential liability, if you will, regarding missing participants. Most of the record keepers are adopting, I would say most, a majority are adopting an approach that are wrapping around an automatic rollover process that occurs independent of auto portability, so those balances get forced out under normal course, right? So you don't have this particular issue. And then to address your question around match probability, it's really, excuse me, the percentage of plans that are in the system and participants. So if all the record keepers that are on board today, if all their plans signed up at 63%, then your match probability is 63%, right? So think of it that way. So that's why it's important for scale to occur, have many record keepers join and have plans join, is because that's what improves your match probabilities.
Yep, makes sense. As well as the speed with which a match is found, probably. Yeah.
So, and then just to follow that up, Neil, Laura, Renee, it sounds like then another way to respond to this question, or kind of a corollary to that, is that to the extent that the configuration a particular record keeper permits would allow a continued wraparound, some type of auto out arrangement, then any concern about this increased risk, would be in the control of the of the plan sponsor, the plan fiduciaries, when they're setting this arrangement up. They could choose a implementation or they could choose to do this in a way that would not increase this risk if they're actually concerned about this.
Correct. That's right, Tom.
Well, we are at the top of the hour. Great information today. Thank you very much, Neil, Renee, Dominic. Thank you all for joining us for the program. Again, as a reminder, a recording of the webinar as well as the slides will be emailed within 2 business days to everyone registered for the program. Our final Secure 2.0 Deep Dive webinar is on November 29th. Please register if you haven't done so. And if there were any questions that you weren't able to ask, feel free to reach out to your Thompson Hine employee benefits attorney, or if you don't have one, feel free to reach out to either myself or Dominic. With that, we will end the call. Again, thank you very much.